Good afternoon. Another YouTube video that we're going to do today, and the topic we're going to do this YouTube video on is going to be what are some of the thoughts that go into whether I should have a trust, do I need a trust, do I not need a trust, can I just do a will, or maybe I don't even need a will, maybe I don't need anything at all. So what are the things to consider and think about and things that we would talk about if you came in to decide whether we need a trust or we can do something besides a trust. Some of the main questions that we always look for to decide, okay, yes, a trust is the right vehicle, or maybe it's just a will, or maybe we don't even need a will at all. Maybe we can just do beneficiary designations or joint ownership on an account, are the following. Always remember that one of the first things people are looking to do by having a trust is to avoid something called probate, okay? There's two types of probate that most people are not familiar with. Most people are familiar with one type of probate, but not both. So two types of probate. One is called living probate, and the other one's called death probate. So two types of probate. Living probate is the one most people are not familiar with. Death probate is the one most people are familiar with. So what is living probate? Living probate is I'm alive, but I lack capacity. I have Alzheimer's, I have dementia, I have Parkinson's, I got COVID, I'm incapacitated, I'm in a car accident, I'm in a coma. For whatever reason, I lack capacity. And I can no longer manage my affairs, my healthcare affairs or my financial affairs. And if that's the case, and we don't have certain legal documents in place to take care of our healthcare making decisions and our financial decisions, then we go through living probate. We go to court and we get what's called a conservatorship and a guardianship issued over the incapacitated person. So that's where we're in court, we're having a judge decide this person is going to manage Dave's financial affairs because Dave can't manage his financial affairs anymore because he's incapacitated, and this is the person that's going to make all of Dave's medical decisions because Dave can't advocate his own medical decisions anymore because he's incapacitated. And that's called living probate. Death probate is the one most people are familiar with. That's where I've died and I owned things. I owned a house, I owned a car, I owned a checking account, savings account, brokerage account, stocks, bonds, mutual funds, whatever it is. And now that I've died, those assets were just in my name, not jointly owned, no beneficiary on them, just in Dave Eastman's name. And now I've died, and now we have to go through probate so that those assets that I owned are gonna go where they should go, or where the court thinks they should go, or where the statute says they should go. And that's death probate. So the number one question we ask when people come in is, okay, are we worried about incapacity? Are we worried if you become incapacitated, who's gonna manage your financial affairs? Who's gonna pay your bills? Who's gonna write checks? Who's gonna invest your assets? Is that a worry? Is that a concern? Is that an issue? Yes, it is for most people. Next question, are we worried about going through something called death probate? When you die, do we want to make sure that there's no death probate, no attorney's fees, court costs, time, delay, all the publicity that goes with court? Are we trying to make sure that doesn't happen? And most of the time the answer is yes. And so if those two things are I want to make sure the right people are in charge of my medical decisions and my financial decisions if I'm incapacitated, and I want to make sure I avoid death probate when I die. Well, then 9 times out of 10, a trust is going to be the best vehicle to do both those things, right? Yes, we do create healthcare powers of attorney and mental healthcare powers of attorney and living wills and HIPAA documents for the healthcare part that's outside the trust. But for the financial part, who do we want our stuff to go to when we die? Who's going to manage our stuff if we become incapacitated? The trust is the best vehicle to do that with. Some of the additional questions that go into that are, what is the size of your estate? You know, if we add up everything you have, house, cars, checking, savings, stocks, bonds, mutual funds, everything you've acquired during your lifetime, what is that total dollar amount? And if we have assets that exceed $75,000 in total, which is the Arizona probate threshold amount for personal property, then we will typically say, yes, we need to have a trust in place. It's the best vehicle to make sure we avoid living probate and death probate. So that's another kind of threshold question, is what's the size of the estate? Most of us have, if we add up everything we have in our checking and savings and stocks and bonds and mutual funds and brokerage accounts, most of us have over $75,000 in that stuff. And therefore, once again, that's leading to the path of what makes most sense is a trust. Another question is when you do die, do we want to try to protect the assets as much as we possibly can for your heirs, for your children, for your grandchildren? And when I say protection, what do I mean? I mean, if when you're dead, your kid gets in a car accident and gets sued, do we want to try to protect the inheritance from that lawsuit? Most of the time, the answer is yes. If after you've died, your child goes through a divorce and they get divorced from your son-in-law or daughter-in-law, do we want to try to protect the inheritance you left behind from your ex-son-in-law or daughter-in-law getting their hands on some of that money? Most of the time, the answer is yes. If after you died, do you want to make sure if your kid racks up a bunch of credit card bills or medical bills, we don't want their creditors coming after the inheritance and taking it from them? Most of the time, the answer is yes. So if we're trying to also protect the assets after we've died for our loved ones, then a trust makes the most sense to do that. Certainly, a lot of people will say, well, Dave, can't I avoid probate if I just title everything I have jointly with my kids or my wife, or I put a beneficiary designation on everything, right? I put a POD, which means payable upon death, or a TOD, transfer on death designation on all of my stuff. Won't that avoid probate? It will avoid death probate if we have beneficiary designations and those beneficiaries are still alive when we die, but it won't protect the assets from the divorces and creditors and bankruptcies, lawsuits, all that kind of stuff we talked about. A trust would. If all we have is joint ownership on the account and one joint owner dies, won't that avoid probate? Yes, that will avoid probate, death probate. But what happens if there's incapacity issues and all we have is a beneficiary designation on the account, no joint ownership? Then we're back to living probate because I am the owner of the accounts just in my name. I've got my kids listed as beneficiaries on the account, but I now lack capacity. I have Alzheimer's, dementia, I've got COVID, I'm in the hospital. Can my kids manage my account if I am the only owner on the account and they're just the beneficiary if I'm incapacitated? The answer is no. Whereas if the account was owned by the trust and I lack capacity, then my successor trustee, my son, my daughter, my wife, whoever, can take over the management of that asset without having to go to court. So a trust solves lots and lots of problems. It solves incapacity problems, death problems, protects the assets for my kids or my loved ones after I'm gone. It can minimize taxes a lot when we pass away. There's lots of things a trust can do that other vehicles or other ways of planning your estate won't take care of. A will won't take care of those things. Joint tenancy won't take care of all those things. Beneficiary designations won't take care of all those things. So just think of it as good, better, best. Best plan is a trust, takes into account everything, protects everything from everything. Will, beneficiaries, joint tenancies don't do those same things. So I hope that helps. I hope that gives you some guidance on when does a trust make sense, what are some of the things you should be looking at as far as should I have a trust or not. Hopefully that gives you some clarity on those things. And certainly if you have questions on any of those things, if you're saying, well, I think I need one, but how do I know for sure? We're always here to give free consultations. We never charge for those. So absolutely feel free to come in, sit down with us. We give you an hour and a half of our time. We don't charge for that. We'd be happy to sit down with you and talk to you about whether a trust makes sense in your situation or circumstance. And by the end of that hour and a half meeting, you'll know exactly what you should have and whether a trust is right or not. We'd be happy to do that for you. Thanks.